This is almost administrative, but I'd like to go through a couple of things with you. You used a term just now. Perhaps you could repeat it. You tried to work consistent with the final enactment of the bill. Could you repeat what you said, or I can have it read back?
I believe what I was trying to say was that in our rulemaking process, we analyzed the Affordable Care Act in its final form, in the manner in which it was finally enacted.
Okay. Well, let's take that, because you're a political appointee. Your job is to do the bidding of the President. The people who did the analysis, I assume, are political appointees who did the bidding of the President. The President wanted the Affordable Care Act and clearly wanted it to be as broad as he could, even when States pushed back and said no. Is that a fair statement, at least from this side of the dais?
With all due respect, I do not believe that.
Are you a political appointee?
I am personally a.
Were the other individuals involved in the analysis primarily political appointees?
No. In fact, they were not. The working group of tax lawyers that did most of the work on development of these regulations included career IRS staff attorneys in the Office of Chief Counsel, and non-political staff attorneys in Treasury's Office of Tax.
Well, great. And where the hell's the paper on that? Quite frankly, you claim to have sent me 500 pages. We got 386 pages, and 154 of them are the proposed rule itself. Where's the analysis? Congress doesn't agree with you, at least the House of Representatives, that your rule is consistent with the law. We asked for the analysis. You've stonewalled us. Where is the analysis? Or are we going to get into the deliberative process? Are we going to get into how you decide to make a decision that's not supported in the law? You're not going to give us papers that effectively tell where that is. Are you prepared today to say you've given us full discovery when you say you have career lawyers who worked on this? Where are the notes, recommendations, analysis that we asked for?
Mr. Chairman, Al Fitzpaine of the Treasury Department sent a letter to you and others this morning that explains our concerns relating to confidentiality and sensitivities relating to the active ongoing litigation, these concerns relating to your request for additional documentation. That being said, his letter did describe the documents that we, additional documents to the ones that you have seen that we discovered in our internal search. And
well, let's go through your search. $600 billion this bill is going to cost, and you tell us there's 50 emails that are responsive to that. Is that really what you're saying? Did you not use email at Treasury?
Mr. Chairman, I have not personally reviewed all of the documents that were discovered in the.
Okay, so it's very possible that there are more documents.
Mr. Chairman, I simply don't know. I did not perform the internal search. That was not done by me.
Okay, well, let's go through it. The deliberative process behind in this letter that arrives in anticipation of your being here, I suspect. Your letter also requests information concerning the deliberative process behind 36B regulations. In addition, you describe a telephone conversation with Treasury staff from March 2013 regarding such information. We disagree with your description, but we've given us no information. I'm going to send you back with a couple of things here today. One of them is this body has every right to the most sensitive information, period. Now, every day we have State Department deliver us classified information related to Benghazi. A keeper sits there. People who are cleared for classified information go through that. If Treasury wants to make sure that information that is known to be such that you do not want it subject to release because of ongoing litigation, tag it. Bring it in here. Let us look at it. If I do not get either in camera all discovery or hauling it back and forth as appropriate and full disclosure, not only will I issue a subpoena, but I'm going to have to do a lot more. The American people are about to spend more money on this program, perhaps, than any other program launched in its infancy. This is very expensive. And you mentioned Medicaid. ObamaCare is effectively simply a Federal pays both sides large Medicaid program. That's really what it's becoming. The Federal taxpayers are going to be on the hook for huge amounts of money. All we're asking for is that you obey the law as written and you provide us information when we believe that you've created a rule that the last panel couldn't find actual language that would allow you to have that interpretation. You've said here today under oath that, in fact, you had a significant number of people, career professionals, who did analysis. You've given this committee no such analysis. I'm sending you back very simply. You were pretty close to a useless witness who came saying, I don't know. And if history is of any indication, the things you said you'll take back for the record, you won't come back with any answers. You didn't send 500 pages. You didn't send 386 responsive pages. You sent almost nothing. The American people, if they're going to spend trillions of dollars, and if they're going to have mandates that are not within the language of the legislation, they deserve that analysis. They deserve it to be non-political. They deserve it to, in fact, have come out of something other than political appointees figuring out how to circumvent a change in the House of Representatives. It's that simple. Thank you for being here. Do you have anything in closing?
No, Mr. Chairman.
Thank you. We're adjourned.